Hi, good morning everyone and welcome to our webinar in which we're going to discuss the really important topic of protecting your employees from harassment. Just to let you know that a copy of our slides will be sent out to everybody after the event in the coming days. So as usual, we like to introduce ourselves. So I'm Victoria Templeton, HR Knowledge Manager here at HR Solutions, and I'm joined today by Sue Watson. Sue's our Operations Director, and together we're going to take you through this topic and explore all the different areas and take your questions. And because we've got so many of you here today, we've placed you all on mute. However, as you know, we do like to get your involvement in to our webinars. And so we're going to be doing that by inviting you to ask us questions. And what you'll see on the screen now is the image of what your GoToWebinar question panel looks like. So please simply type in your question and then we'll aim to read out and answer as many as we can at the end. If this isn't possible, then we'll follow up afterwards. And another way in which we'll get you all involved is through the use of polls. And as you'll know when we're about to run one, because you'll see this slide, and we find that polls are really helpful not only to the running of the webinar, but actually we find that it helps everyone in attendance just gain an idea of what other businesses are doing or thinking on the particular topic. They are confidential, we just know the numbers of how the polls are voted on. So do please get involved if you can. So in terms of our agenda this morning, I'm going to begin just by setting out the current laws that are relevant to the topic of harassment. And then with the forthcoming new legal duty that's to be placed on employees from October, I'm going to be taking some time to share with you what that new Worker Protection Amendment of the Equality Act is all about. And then we'll look at what this will mean for employers moving forward. And then we'll finish with Q&As as usual. And we're going to begin the webinar by just running some quick polls. And really it's just to understand first of all the context of your business. So really the first question is quite broad. Not all of your business areas may have the same extent of interaction with third parties, but really just let us know as to the extent of which you interact with third parties, whether they're customers, clients, recruitment agencies, etc. Right, let's just see, are the polls working? There we go, let's see. I've just had a few technical problems there. So, and there is reason for this, as we'll come on to explain in the webinar.
Okay, I'll close the poll and share those results.
Okay, so 68%, actually, yes, so very common and frequent. That's quite higher perhaps than what I was probably anticipating, but it's nevertheless interesting. And then for 26% of you, there is some interaction, and then obviously the small proportion of you that have limited or really not much interaction. And as I said, we'll come on to explain this in a little bit more detail around the position with third party potential harassment. And then we already, we have a second poll, and it's around the policies in your organisation, just to let us know which of the following that you have. Okay, let's
close that. Share those results. There you go.
So let's take a look then. So most of you have a bullying and harassment that incorporates sexual harassment, and then just 4% of you have a standalone sexual harassment policy. And I think that's an interesting one, and I think as we come to talk about the new laws from October, it'll be interesting to know whether we have people move to having a standalone policy in that area, and then 48% general bullying.
Again, back to you.
Thank you. So thank you for that contribution. So I'm going to run through current harassment laws. There are several pieces of legislation. Not all are employment legislation, but they're still relevant for today. And what we're going to look at, first of all, there's the statutory duties that are central to the employment contract. We have the Equality Act of 2010. We have several health and safety pieces of legislation, as we've noted here, the Main Act from 74 and the Workplace Health Safety Regulations of 92. And then there's also the Protection from Harassment Act of 1997. So generally in terms of employment, we think that generally most of the claims are brought under the Equality Act. So I'm going to spend probably a little more time highlighting the Equality Act and the importance of this legislation. But nevertheless, these are all relevant when it comes to harassment in employment. So I'll begin with the statutory duties, and there are several. So fundamental to the employment relationship is the employer's duty to gain the employee's trust and confidence. And we know through a really old case ruling what that guidance is as to what we mean by trust and confidence. And in the Malik and another versus Bank of Credit case, it ruled that employers must not, without reasonable and proper cause, conduct itself in a manner calculated and likely to destroy or seriously damage the relationship of trust and confidence between both parties. So this is obviously relevant because when you're dealing with matters of a harassment nature, then this really brings into question the nature and the trust and confidence in that employment relationship. You then have that duty of care for on employers to take that reasonable care to protect employees from foreseeable harm. So, for example, if you are in an environment that there's, if I think of perhaps hospitality where there's lots of alcohol flowing, you've got lots of interactions with third parties, then obviously that's a very different environment to perhaps an office environment. So it's about understanding your duty of care in the context of your organisation and the business. And then there's that duty of fidelity. In other words, it's about, as an employer, responsibilities and duties to act in good faith. So really, how an employer prevents, responds to and addresses harassment in the workplace is really crucial for upholding these duties and critically fundamental for the employment relationship moving forward. But I mentioned a moment ago that typically most claims will be through the tribunal system as an inequality, breach of the Equality Act of 2010. And it means to bring a claim under this legislation, that person must hold a protected characteristic. Interestingly, as you'll see here on this slide, I've highlighted by different colour fonts. So there were 2 protected characteristics where there's no scope to claim harassment, and that is the marriage and civil partnership and pregnancy and maternity. It isn't to say that those employees are excluded. They absolutely are. It's just they have a different avenue of recourse through the Equality Act to claim for a breach of the Act itself for any forms of harassment. But when there is a claim connected to a protected characteristic, it is for those that are in the pink highlight there. And just to flag, for those that may have operations in Northern Ireland, there's an additional protected characteristic, and that's that political belief. So the Act itself does provide that definition of harassment, and it's unwanted behaviour, whether it's intentional or not, and it has the purpose of violating dignity or creates that intimidating or hostile, degrading, humiliating or offensive environment, and that's taken from the Equality Act, as I said. But just really to bring your attention, this is obviously a quote from the Act itself, so it's very legally worded, but if I can kind of high level express what it means. So it's when person A harasses another person, so person B, and they engage in unwanted conduct that's related to a relevant protected characteristic, as I've just said on that previous slide, and it has that purpose or effect of violating their dignity or creating that intimidating, hostile, degrading, offensive environment for person B. But harassment can also occur when person A engages in unwanted conduct of a sexual nature, so it makes sexual harassment a specific offence, and that conduct has a purpose effect of violating, again, the person's dignity or creating that intimidating, hostile environment. And then there are the aspects around when person A harasses B, or another person engages in unwanted conduct of a sexual nature, or that is related to gender reassignment or sex. And again, it's about that conduct having the purpose or the effect of violating their dignity and again, creating that intimidating, hostile environment. So harassment is quite broad in terms of the relevant protected characteristics, and then it narrows down also because there's avenues for claims of sexual harassment and those that are related to gender reassignment or sex. So just to sort of understand and put that into practice, what that means. So it can be unwanted physical conduct, so unnecessary touching, brushing against another person's body, insulting behaviour, obscene gestures, physical threats, aggressive behaviour, assaults. You then have unwanted verbal conduct, so unwelcome advances, nicknames, patronising titles, insulting comments towards people, you know, that's unwanted verbal conduct. And then you've got the non-verbal, so racially or sexually based graffiti, graffiti that refers or relates to an individual characteristic, that graffiti that's offensive. So there's many forms of potential harassment, even as non-verbal conduct. And then you have bullying, which can include virtual bullying, so unwanted physical contact or assault, threatening comments, belittling, embarrassing somebody, personal abuse. You've got, if we think about the virtual side of things, distribution of unwanted emails, text messages, texts sending images, humiliating data that's published on social networks. I mean, there's quite a broad range there. And then we have the conduct of a sexual nature as well. So unwanted physical, verbal, non-verbal conduct, similar to what we've discussed, that's obviously of a sexual nature. Examples can also be of a coercion, so threats of dismissal, or if you don't do this, then you won't get that promotion, for refusing, you know, of sexual or other favours. And then there's areas of harassment that are about the isolation or non-cooperation at work. So that deliberate exclusion from communications that may include group emails, conversations, social activities. You know, there's lots and lots, and as the slide heading says, it's not limited to these, but this is a good illustration to sort of highlight how harassment can occur and in what form. So I'm going to just talk a little bit more about harassment under the Equality Act. As I said, it's the main area for claims at the Employment Tribunal. So first of all, harassment can be ongoing or one-off act, if you like. It can take many forms, from a joke or banter to actual physical violence. It can also be intentional, obvious or violent, unintentional, subtle. There can be nicknames, gossip, intrusive or inappropriate comments, questions, and as I said, coercion, such as threats of dismissal, loss of promotion, that isolation of somebody, excluding them from activities at work. So it does cover many areas. there. And if we think about under the Equality Act, it actually says that it doesn't matter whether the alleged harasser possesses the same protected characteristic of the alleged victim. What's important is, the perception of the individual who was allegedly harassed is usually more important than what the intention was of the alleged harasser, which, why I mentioned on the previous slide, it can be intentional or not. The complainant need not necessarily be the person towards the harassment is directed. So you may be familiar with discrimination by association. So if they know somebody associated to somebody that perhaps may hold one of those protected characteristics, and the comments, the banter is about that, that's where they can have an avenue for a complaint. And someone who witnesses harassment towards another person is also legally entitled under the Act to bring a claim, even if they don't share that protected characteristic. But within the Act itself, it does explain how a harassment won't have taken place, and that's when the effect on the alleged victim is wholly unreasonable in the circumstances. So was that person really taking it out of proportion and unreasonable in their response to whatever it is that happened? Obviously, that's a really difficult area to argue, and ultimately it's down for that tribunal to assess the claim in line with that aspect of the Equality Act. So each case will have its own set of circumstances, and therefore what is reasonable is difficult to define. But essentially, if a tribunal finds that the victim's response was unreasonable, then they won't find in favour of the harassment of occurring. So in terms of the tribunal process and recourse, claims of harassment in general could give rise to your discrimination claims. So with discrimination, there are uncapped awards, and you don't need any qualifying service to lodge those complaints. And if you remember on one of the earlier slides where I talked about the contractual relationship and the fundamental aspects of that, where there's breaches in that employment relationship, you can get claims from unfair dismissals, automatically unfair dismissals. Now, currently, you need your 2 years qualifying service for those claims. Under the new government, they're proposing in their manifesto that that 2 years is abolished, and that actually, at some point in this next parliament, the 2-year qualifying service will be removed. But until that point, it is that 2-year service. The automatic unfair dismissal, sorry, just to clarify, you don't need the qualifying service for that. It's a day one right. And then, of course, they've got recourse from a breach of contract point of view, and claims of constructive dismissal. So where there's those serious breaches of that contract, that relationship, and the employee has no other option but to resign in response to the actions of the employer. So when a tribunal looks at harassment, they are concerned with 3 aspects. So the effect on the employee, by considering the victim's perception. Perception is really, really key. And this links into what I said a moment ago. It's the judgment will be around whether their response was reasonable or not. Obviously, they'll consider all the other circumstances of the case, and whether it was reasonable for the conduct to have had that effect. So before we finish on this section and move on to the changes in the law on harassment, just to flag, there are other pieces of legislation, not obviously all employment. So we've got the Health and Safety at Work Act of '74, and Section 2 is about an employer must take reasonable, practicable steps to ensure the health, safety and welfare of its employees. And when you have the Workplace Regulations Act of '92, there's that overriding duty on employees to make workplaces suitable for those working in them, and as part of that duty they must assess the health and safety risks and the risks of the health and safety to others. So again, if we think about third party involvement and assessing the risks, a risk assessment for a business operating in hospitality, for example, would be very different to a risk assessment that is developed for an office-based environment. Yes, there will still be risks, but the extent of those risks will be very different because it's a completely set of different circumstances. And then finally, you've got the Protection from Harassment Act of '97. And actually, this wasn't designed to deal with harassment occurring in employment. It is a criminal convictions can come on the back of it, but it could apply in certain circumstances. And so, you know, because harassment under this Act can be a criminal offence, it means that individuals can be liable, so not just the employer. So employees within your own workplace, if they're found to have breached the Protection from Harassment Act, then that's where there's potential liability for them to be given a criminal offence. Harassment in this Act is essentially behaviour that causes alarm or distress, not necessarily related to the protected characteristic, which is what the Equality Act addresses. So it might be things in this instance, you know, stalking somebody. So that's a run through of the legislation. I appreciate there's a lot, as I said, the main one being the Equality Act, but we do have changes coming up in October that we're all going to need to prepare for, and that's the introduction of the Worker Protection Amendment of the Equality Act of 2010, Act 2023. Always have long titles. But this legislation specifically deals with sexual harassment. So it's going to come in force from the 26th of October, and what it will do is place a new legal duty on employees to take reasonable steps to prevent the sexual harassment of workers during their course of employment. And what we need to be mindful of during the course of employment could include the recruitment stages or the ending of employment when perhaps you're asked to provide references. So, and also another aspect is, you know, work social events. You know, it's really important to consider that even though an event might not happen during working hours, it could still be a work event and therefore the employer liable. So the new duty will only extend to sexual harassment, so it doesn't extend to harassment that is being based on other protected characteristics. So we ran a poll earlier around the third parties and to what extent your organisation has involvement with them. The legislation itself, there isn't a specific legal duty from what we can see in the Act to protect workers from a third party harassment. However, yesterday we had the publication of a updated guidance document by the Equality and Human Rights Commission. Now, they have a code of practice in place. It's been in place for many years around how employers should be managing and preventing, managing and responding to harassment. They've now opened a public consultation, I think running through until about August. And it's essentially they've updated their guidance in line with this new protection. And whilst the Act itself doesn't include a specific legal duty around third-party harassment, the updated guidance says the preventative duty includes prevention of sexual harassment by third parties. Therefore, if an employer does not take reasonable steps to prevent sexual harassment of their workers by third parties, the preventative duty will be breached. So we absolutely would advise developing policies to ensure third-party harassment is addressed, about, you know, your position on it, what your response would be, and essentially the fact that it's not tolerated and what steps are in place to prevent it. Now, when we're in a tribunal situation, a tribunal will consider a client and employer's overall approach to how they prevent and deal with sexual harassment when they're considering if the employer has taken reasonable steps. So there may be some circumstances that by including protections from third-party harassment may count towards you demonstrating having taken reasonable steps. So we'll know more once we get more on this consultation that's currently open. as I said, I think it runs through to August. What then normally happens is they'll review all the responses and then they'll provide a response and a final draft of the publication. And so we'll revisit the advice and the situation at that point. But it's really important to be mindful, especially if your business operates with third parties. So we're going to look at what this new duty will mean for employers, but we're going to just run a quick poll at this stage, which is focusing on the matter of training. And it's just really to gauge an understanding about your current provision. And this is general harassment in the workplace.
Okay, just collecting those responses.
Thank you, Sue.
At least the polls seem to be loading okay now.
Yeah. I don't know before, but it's okay now.
Okay, I'll close that and
Okay.
share the results. So there we go.
15, 50. Okay, so yeah, so the training is provided for all employees regardless of job levels. So it's a kind of a blanket approach, 35%. And then there's 15% of you that do separate out employee training and then management training, which I think, you know, there's a good argument for doing that because managers have those responsibilities. And so there are certain other pieces of information or education that you would need to give a manager that you wouldn't necessarily need to give an employee. I think we know through case ruling the importance of training your employees on harassment, and I think as we get this new legislation coming in October, there'll be more of a greater responsibility for employees to have training in place in that area, because essentially you know, it's about educating employees about what the company doesn't tolerate, the how it's to be managed, how the business responds, takes action. So training is really important, and it will flow nicely onto our second poll here that we have, which is about if you do run training, how do you describe the approach you take? Is it a one-off? Do you regularly sort of provide, perhaps on an annual or even more frequent basis, maybe depending on your nature of your business? Or do you only provide it following complaints that you get in? If you do, hopefully you don't.
It's an interesting point about the training and the importance of training to implement policies, because in a lot of tribunal cases, the rulings are stating that there was no evidence that while there was a policy in place, there was no evidence that it had been implemented and that the staff were aware of it. And training is one way you can evidence that you have explained to staff the policies there, the importance of it, how to implement it, how to manage it, how to spot things that you might accept personally, but you need to understand when for somebody else that might not be acceptable, and what you should do about it. So I think, and that's raised in more than one case ruling, is the importance of training, especially in the mental health cases, which are obviously more difficult to assess and rule.
From memory, we had a case about 12 to 18 months ago that really specifically, as part of the judgment, made comment about the fact there wasn't any refresher training. So it is crucial and is one of your defences at tribunal, like Sue says. So
so there we go, that's the results of that poll.
And you know, it's really good that having training on the back of any complaints you get is also important. Obviously not, you know, you might not have had complaints, but when they do happen, you know, it's an opportunity to review your working practices and perhaps make changes moving forward to methods in what you do or the content itself. But yeah, okay. Really good input. Thank you.
Back to you.
So in terms of the new regulations that are coming in October, what happens where there's a breach? So a breach of this new duty, I'll try and keep it simple. It will only be found to be a breach where the tribunal have upheld the claim for sexual harassment. So there needs to be a successful claim first for that sexual harassment, and then they'll look at actually have they breached that duty. It's not a standalone claim, but this is probably more of a technical piece. Probably not necessarily. It's more of a, as I said, technical piece. So when a claim of sexual harassment has been upheld, and if the tribunal believe that this new act has been breached, they can make an uplift to the compensation that is given towards the employee by up to 25%. In terms of the breaches as well, there's going to be new powers given to the Equality and Human Rights Commission. That's more about how they enforce the regulations. And then remember, to avoid a breach, it's about the need to take reasonable steps to prevent the sexual harassment of workers, and as I said, during the course of employment. So if you're planning your Christmas parties already, just think about your risk assessments and think about how the risk of sexual harassment may increase if there's unlimited alcohol flowing, for example. It's not just during the working day, it's work, social events. It can be part of the recruitment process, or even, as I said, when people leave and you're providing references verbally or not. So the difficulty is not knowing what a reasonable approach is, because ultimately that's a view for the tribunal, but we know from previous case rulings of what the core factors are for taking a reasonable approach. And just remember that, you know, what approach for one business context could be very different to another, like the examples I've expressed earlier. So we're going to look now at what reasonableness may look like. And I think we, Sue may agree that we find it difficult with the word reasonableness. It's not very helpful. And that's why we have to go by previous case judgments to guide us. So what we know from the ECHR already in their guidance, it's about employers having the prompt approach to when they're dealing with complaints. It's about having proper and thorough investigations, leave no stones unturned, taking the appropriate action. So where there's been a breach, follow up with that breach and take action through your disciplinary policy. And if you say something's an act of gross misconduct, uphold that potential that warning for that situation. Obviously all depends on what the case and the circumstances, etc. But what I'm trying to illustrate is enforce your disciplinary policies when you need to. It's about creating an anti-harassment policy that's monitored and reviewed. So it's not just about putting one in place and then forgetting about it. You really need to check that it's working, it's effective, it's giving you the ability to ensure that all preventative measures are taking place and communicating it. And having a clear statement that sexual harassment will not be tolerated, that it's actually unlawful, can lead also to disciplinary action up to and including dismissal. I think it's going to be important as well for employers to recognise that there could be certain aggravating factors in the workplace, and this is what will need to be picked up as part of the risk assessment as well. You know, could there be abuse of power over a more junior colleague, for example? You know, in terms of considering when disciplinary action is taking place, you need to be able to understand that there could be certain aggravating factors. Or if you're in an environment where the alcohol was free flowing, like I've mentioned a moment ago. It's also important to define sexual harassment and provide clear examples, but not just a blanket approach of just any example. They've got to be really relevant to your working environment, and that they also reflect the diverse range of people that harassment may affect. Because having those really specific, clear examples really helps employees to understand what harassment may look like. It's about establishing effective procedures for receiving and responding to complaints, and importantly, that appropriate training, which is fundamental. And what Sue and I have just said, we see it in case judgments being referred to, and they just highlight the importance of it's an essential, essentially. And then when it comes to addressing the third party harassment, it's about having clear statements that it won't be tolerated, that you encourage your employees to report it, you set out in your policies around the steps you take to prevent it, you communicate it as necessary, and you set out the steps that will be taken to remedy a complaint or prevent it. So it might be your working environment could allow you to put posters up. It may be the working environment means that you need to put like excuse me, a message at the start of the phone message when somebody calls it into a contact centre. It's taking steps like that that are really sort of getting the message across that you do not tolerate it as a workplace, and that's important. So between now and October, you know, start having a think about what other extra steps you could be taking in all aspects of harassment, sexual harassment in particular, but also at the third party as well. So before we get to questions at the end of the webinar, we've got a few, or one more poll, I believe.
Mm-hmm.
And this is really just to understand the extent to which the steps you take, and hopefully give you some thoughts about where you may need to, the steps you need to carry out over the coming months ready for October.
And while we're just running that poll, if you do have any questions or comments or feedback that you want to send us through the question panel, then do send them through. We'll be moving on to those shortly. Okay, I will close that poll and share those results. There we go.
Okay, so good data there. So monitoring and reviewing, yeah, that's really high. That's good, because it is so essential to making sure that they're still fit for purpose, that they are robust enough to deal with complaints. If you think about the use of social media, for example, in more recent years, perhaps if you haven't updated your policy for the last 10 years or 5 years, then absolutely look through to see how you need to incorporate harassment that could come about from social media use. You know, so it's really important to regularly review them. But yeah, any thoughts, Sue, from your perspective?
No, I think it's as you say, it's good to review them. I think if you do make references to the legal references in the policy, then don't forget to add the new one that's coming in, and just make sure that that there is adequate cover for the new duty of care for the new act. But other than that, if your processes are effective, then that's good. And perhaps just review that they are all totally compliant with the new requirements. That's all.
Yeah, and you'll get a copy of the slides. So that table that gives examples of what may be reasonable will be on there. But as I said, just remember it's what's relevant to your workplace and your context in which you operate. So let's.
Okay.
And now we're over to questions, if we've had any questions.
Yeah, I'll just close that poll. It's all right, my poll panel was sticking again. Okay, so we've had a couple of questions. One question, sorry. How do you deal with a sexual harassment complaint when it's one word against another? It's that whole issue of perception, isn't it? If somebody perceives, even if the other person say it wasn't intended, it's the perception. But how you deal with it when there's clearly arguments on both sides, it just has to be handled really carefully. But if somebody perceived they have been harassed, then you have to take it seriously, say, even if the other person's adamant that that was not their intention or they haven't, it wasn't intended that way, or they certainly didn't portray it in that way. So the thorough investigation, I think, is your only way through, isn't it? And exploring if there's any
really
other
tricky.
witnesses.
Yeah, it's really tricky, and there might be other things to support that get drawn out through an investigation. There might be a history of some emails, for example, that at the time when they were sent, not necessarily perceived as, you know, not to be right, but actually when you look at the relationship between the two people, is it a build up of it, and eventually, you know, so there's lots to talk about in terms of the investigation, what may get drawn up in that, and also the effect on the people. And, you know, when you do investigations, what's really important is doing face-to-face meetings with people, because when you're looking people in the eyes and you're having those conversations, there is a lot that comes from how the people, I guess, interact in those discussions, and you're able to probe and ask follow-up questions. But there's normally some other things to pick up that can perhaps support that case either way, whether it is likely to have occurred or not to have occurred. And remember, in terms of employment law, it's forming that genuine, reasonable belief. It's not beyond all reasonable doubt, and that's why your investigation needs to gather as much evidence. You weigh it all up, and then you work out where the scales, balancing scales lay, I guess, if it's more likely it happened than it didn't. But it can be difficult when you've got those situations.
It is very difficult, yeah. So another couple of questions. So one is, can a statement on sexual harassment be a part of an anti-harassment policy, or does it need to be standalone?
So I'm thinking that perhaps as we get nearer to October, ready for the new law, I think there'll be some businesses that will need a standalone, or will be probably best practice to have a standalone policy that's specific to sexual harassment. And I think when I'm thinking certain businesses, like I keep talking about hospitality, I'm just thinking of like pubs and hotels and restaurants and things where alcohol is flowing.
And there's a lot of social interaction, isn't there?
Exactly. When there's a high social level of socialization with third parties, I think that kind of organisation would probably be wise to have a specific focus on sexual harassment, because of it being an additional duty. But equally, you know, there's still importance of your normal bullying and harassment policy, but I think it should stand out as a standalone one. Whereas an office environment, you know, it can be probably incorporated into your existing policy. So I think the starting point is your risk assessment. Understand the extent, the level of risk that you have in your business, your line of work, who it impacts, to then determine the best approach for your policies.
Okay, thank you. So another one, slightly more unusual one. So if an employee tells HR about a new hire who had sexually assaulted her years ago, but she hadn't reported it, and she feels threatened by him being in the building, could we end his employment as a response to her distress? I think that's another one that's going to need a thorough sort of investigation and a understanding about, I mean, potentially, if there's no other alternative, there's only one building, there's only one, do they need to come into contact? But yeah, I think that one would need looking at the case.
Yeah, I think the starting point is the investigation, you know, to understand the extent to which that person perceives the risk and the interactions they're going to have. But in theory, potentially, if facts come through that process that it's reasonable for that employee to have those concerns, because remember when we talked about what a tribunal considers, was a response reasonable? Then if it is reasonable through your fact finding, then it's taking the appropriate actions in that situation. And one of those as an option could be to separate employment with that person. It sounds really hard to talk about when it's, I guess, unknown, but obviously that will always be an option. It's not, I'm not saying it's the only course of action, because there could be other actions that you can undertake, perhaps. There's too many ifs and buts, but in theory, if it seems that it's reasonable for the way that employee is feeling and perceiving the situation, and therefore there needs to be steps taken by you as the employer, then it's about taking those appropriate steps, whatever they may include, which could be including one of the options of parting ways. As harsh as that sounds, but
it is hard, but it may be the only solution in the end to but yeah, difficult one. And another question about third parties. What does it include? Customers, obviously retail in particular, I'm thinking about, although the relationship's obviously much shorter. Would that, you know, how would you control those third party harassments? I mean,
so
it's the same in a lot of service industries as well, isn't it? Sort of like the ambulances and the hospitals, you know, their customers might not be retail, but they are the patients or the people coming into contact with them, or families of patients, and I'm imagining it's all third parties, isn't it?
And it's things like having those posters that you tend to see, like statements, in our staff will not be spoken to in a, you know, whatever.
Exactly.
Those which you see a lot, don't you, in ticket offices, reception desks. I
think that statement perhaps needs to go behind the till desk, you know, the customer service desk, and it'd be really clear that it won't be tolerated, because that's your duty to protect your staff from everybody they come into contact with, whether that be other staff or customers or third parties in any other context. So yeah, I would think it would be, you should widen the scope. Should HR run training on gender equality as part of a gender equality roadmap and have a gender action plan in order to prevent sexual harassment? Is that a good policies approach? I think it's that and everything else, isn't it? I think that's the thing. Not specifically, I mean, obviously we're targeting sexual harassment, but on the grounds of a protected characteristic, and it could be any number of protected characteristics. So yeah, I guess.
Excellent. So a gender equality action plan.
Yeah, should they run training on gender equality? I think at that understanding any aspect of protected characteristics training is almost a requirement, isn't it?
EDI training, equality, diversity, inclusion training, is a fundamental area of training for businesses. Then, in addition, whether or not it's probably a standalone training session that deals with harassment, because EDI is such a large area that covers a whole entire employment cycle. So a separate training program for harassment, which may include the sexual and those sectors that have high levels of interaction with third parties, or where they're exposed to risks that may present the chances of sexual harassment more likely to happen, they might want standalone sexual harassment training. Do you see what I mean? So it all depends. It comes back to your business in terms of what your action plan is like in terms of your training and how you break your training down. It needs to cover all those areas, but how you do that needs to work with your business.
Yeah, absolutely. And then on a slightly different angle, how do you try to distinguish between someone feeling harassed by conversations between others in the workplace as opposed to someone feeling offended by others who do not share their beliefs?
Can you repeat that? So
It's distinguishing between someone feeling harassed by conversations between others in the workplace, so they feel harassed by others
what others are talking about,
as opposed to being offended by those who don't share their beliefs, because that's quite a different context, isn't it? I think again, it's an investigation as to why those conversations are, why they feel harassed by those conversations. What is the content of those conversations? What is the intention? Is it people just exploring a topic, or is there something in the way they're responding to that topic that's the reason for the conversation? Okay, I guess it depends on what the conversation is, and
context is everything, isn't it?
It is, isn't it? And so again, a thorough investigation as to what's happened and why. And it may be that, and then taking it reasonably, is it a case of just saying that you can't have those conversations in the workplace because they are distressing to some people, and yeah, it might not be. I think the not sharing the beliefs can be indirect discrimination, can't it? But it's quite different. If you're feeling harassed, that will be dealt with separately, because the legislation is quite different in dealing with harassment cases to discrimination cases, isn't it? So yeah, I think you'd have to understand the full context of that and explore what options can be taken to resolve it.
And I suppose it goes back to the point around, was the person on the receiving end reasonable in their response to it as well?
Yeah, it's looking at both sides, isn't it? And before you decide what action, if any, you take. But remember, it's perception, so it's a hard obstacle to.
They can be really difficult cases, can't they, to manage? But also the sensitivity of it all, and the parties, and trying to obviously, you know, be neutral, make sure a fair process is taking place for both parties. But it can be very difficult to manage, and that's why if you've got EAPs in place, they're a really good tool for directing both parties to getting some outside support that's confidential. Because there's only so much that you'll be able to communicate, and that is around how a process works. You won't be necessarily able to comment on circumstances that obviously other than when you're dealing with a case. And so having an EAP is really important, and that might form, sorry, while I'm thinking about it, that might form a part of a reasonable approach to preventing harassment. So if you introduce an EAP scheme, because it's how you are, if it was to happen, then how you're supporting somebody, I guess.
Yeah. So yeah, absolutely. I think that's all the questions now. Thank you.
Wonderful. All good questions. Thank you. So let's move the slides on, and it's just to bring the webinar to an end, and as usual we just like to run through a few slides, and it's just to remind you that we offer a HR knowledge base. Now that's our online HR resource, and we have over 600-700 articles that covers the entire employment cycle. We also offer all of our templates, so policies, so you'll find your harassment policies, and we will be creating a new specific one for sexual harassment on there. All the letters, forms, anything you can think of are all available on there, and guidance as well. So do let us know if you're interested in that part of our service. We do offer training courses, so we will be looking at our schedule to support the changes in the laws around harassment, but we have these, for example, that have long been in place. As you can see, equality, diversity and inclusion is also on there, and then we offer accredited training courses, so the ILM, both level 3 and level 5. So if you are keen to find out more about how we can support your business on training your employees, your managers, then there's a QR code here, so please scan and get in touch with us. We have a fairly new webinar schedule that we launched last month. So just a reminder, next month it's all about TUPE processes because the laws have recently changed on that, and there's a big consultation going on at the moment around reforming TUPE. And obviously with the new government, they've also got ideas around how TUPE protections may work moving forward. In September, we have our webinar that is all about the employment landscape. Now we know the outcome of the general election. So we're going to be really homing in on what the Labour Party are committing to. And let me tell you, there is a lot. So we'll be covering that in our September webinar. And then in October, we're talking about understanding risk when managing people. So this will follow on to some extent from what we've talked about today, but we'll be looking more broadly as well around risks and how you can prevent or protect your business from risks. And we have 2 more scheduled as well, so November, December. Managing work-related functions and events. So I've briefly mentioned that as part of this topic. That'd be a really useful one to come along to. And then obviously the HR year ahead, we tend to do that each year. And it's looking forward to what we're going to expect to see on the horizon next year, both in terms of HR best practice developments, legislation, case rulings that may have come out end of this year or that we're expecting next year. So do sign up for our webinars. They're all free, and you can access that through the QR code there. It's been a few months now, but we have a white paper that we launched where it shares our experiences and thoughts and research on strategic HR thinking and how you can align the people and the business strategy together. So it provides you with the wealth of information with a key focus on both the current and developing trends in the area of human resource management. So you can download it for free. So again, we've got the QR code, or you can visit us directly on our website as well. And just before we go, we would like to find out from you if you would like us to get in touch with you on any of our services, whether it's our training, payroll, retainer services, helpline. Let us know and then we'll be in touch.
I'll close that now. Sorry, there's been a little bit of delay with the polls coming through at the moment.